we are weekly, even daily, absorbing what feels like real shocks to the Constitution and the rule of law that impel us to consider, as we don't day to day, the Charter's role in our lives and reflect soberly on its potential limits to solve all that may ail us. So we have the privilege today of taking up these perennial questions through the vantage point of a substantial new work by really one of our leading historians of the Constitution. And by new, I mean spanking new, not even officially published for another week. People are going to be reading about it all over the country. It's going to be the cover story in the Atlantic, and the author will be on all the sort of official media tours, but we have it for you today, and you have it here signed. But I think of this conversation as an ideal platform to think about the distance between the Constitution as it governs us now, today, and the Constitution as it was written in a particular year by particular people whom we venerate, but who put their stockings and buckled shoes on one at a time. So it invites scrutiny, both of the State of the Union when it was established, and also the question whether it's been able to keep step with the highest ambitions of a changing society. The book, of course, is We the People, A History of the U.S. Constitution, and its author, I'm very pleased to welcome now the great Jill Lepore. Jill, could you come out, please? You'll have to sit through a couple and comb me out, but Jill is the David Woods Kemper 41 Professor of American History at Harvard University and a Professor of Law at the law school, a full joint appointment, and a staff writer at the New Yorker, where many of us have become familiar with her work. Even those titles, I think, understate her range. She writes about American history, law, literature, civil society, and politics. Among her many, many awards are the American History Book Prize for her work, The Secret History of Wonder Woman. She's been elected to the American Philosophical Society. In 2021, she won the Hannah Arendt Prize for Political Thought. She is one of our most celebrated historians and journalists. And by the way, she began her distinguished teaching career at UCSD. So welcome back to San Diego, Jill Lepore.
Thank you. Thanks so much.
Yeah. Before we begin, I just wanted to thank two important partners. First, the Prebys Foundation, which is the largest private foundation in San Diego, investing in arts, youth, healthcare, and research. It was a gift from Prebys that made it possible for us to invite many of the high school students and teachers from around San Diego, with the participation and partnership of the San Diego school system, to attend this afternoon, to receive copies of Jill's book, to follow up with their own students. And thanks in particular to Grant Oliphant, who's president and CEO of Prebys, who has brought his community leadership skills from my old hometown of Pittsburgh to my new hometown of San Diego. So wherever Grant's going, and I hope it's nowhere, I'm going there. Thank you very much, Prebys. Second, I wanted to express my thanks to KPBS, who partnered with us for today's program. You may have seen their table outside with information about their own democracy project in commemoration of Semi-Quincentennial Day, called Public Matters. And they're going to continue these kinds of conversations about democracy, the history of our country in particular. KPBS is going to broadcast a new documentary by the great Ken Burns called The American Revolution. It'll premiere November 16th in 6 parts. Promises to be an intriguing look at the birth of our form of government as only Ken Burns and his team can tell it. So don't miss that. But now, let's have a conversation about we the people. Thanks again for being here.
Yeah.
So first, I just want to say, it's a great book. It's a keeper. And it's got so many anecdotes that we won't be able to cover today about the people who really were in the trenches, usually unsuccessfully, going for different kinds of amendments and changes to the Constitution and those who opposed them. Let's start with the title, which I think is more layered and meaningful than it first appears. We, the people. It's, of course, the opening line of the Constitution preamble, but it also is a sort of historical assertion in its own right. Yeah, it encapsulates the very idea of popular sovereignty, authority not in the states, not in the monarch, not in a legislature, but we, the people. Who the hell did these we the people think they were? And whom were they writing for? Did they know it was going to be a success? How sort of Promethean the development is just this assertion of we the people, or what you could call popular sovereignty at the time.
Yeah, I mean, I think the thing about the phrase is I think of it as the most richly amended 3 words in the American version of the English language, in that it is a new idea in 1787. More specifically, it's a new idea in 1776. So everyone knows that, in 2026, we're celebrating the 250th anniversary of the Declaration of Independence, the birth of the United States, but it's also the 250th anniversary of the first state constitutions. Because when the war began, the British royal governors just got in boats and fled, went back to England, and the colonies, the new states had no governments. They had to come up with governments. And they decided they would write down their fundamental law, and that they would, not all of them did this, but they would elect conventions of delegates from the people to figure out what the new government should look like, and then they would send that draft to the people to ratify it. We the people comes from the Massachusetts Constitution of 1780, which is we the people of Massachusetts. And it was a really new idea. It was a brand new idea. It was a new phrase, and it meant something quite visceral to people at the time. It's very easily to be distracted by, well, who were the people? It was just a small set of people. It was white men who owned property, and that's absolutely the case. But nowhere else in the world did so many of the people make decisions about how they would be governed. So I think we take the phrase a bit for granted, and I think it's also for a phrase like that to become empty of its meaning. I don't really think Americans today believe themselves to be the authors of the Constitution. But the whole idea of the Constitution and of those state constitutions is not only did the people elected by the people write them and ratify them, but we all have to always be constitutionalizing them, accepting them, amending them, revising them. By not revising them, we accept them in their unrevised state. So I just don't know. I mean, I'd be curious, how the audience feels like. Do you feel like you still are, or ever were, the authors of the Constitution of the State of California? You guys have ballot measures all the time. We're amending the Constitution.
I mean, the states have been much, much more active in amending, which turns out to be the sort of focus of your project, than the federal government has been. Massachusetts is a great example. It's, I would say our Constitution, the U.S. Constitution, is the oldest and most venerable, but the Massachusetts Constitution, written mainly by John Adams, really exercised a kind of pull over all the different colonies, and yet many colonies thereafter got into the act and authored constitutions that were certainly not on all fours with what Adams had done in Massachusetts. Why were the the individual states so active? And is that what kind of gave rise to the movement to actually do a national constitution?
Yeah, absolutely. So, like, just imagine if suddenly there was no federal government. It's not maybe that hard to imagine. Okay, imagine like really we're starting from scratch again. Like something even more cataclysmic were to happen than what's happened. We're like, okay, and somehow the state constitutions didn't work either. Every state has to come up with like who's going to be like. There's no governor anymore. There's no state assembly. Like we have to invent it all. Well, every state would kind of do its own thing, right? These states have different cultures, right? Like you might find some of the Western states would have like very pro-environmental constitutions. Like starting from scratch, they might, do all this kind of protecting of natural habitat or wildlife species or whatever. You might see protections of industry and a wholly new constitution in a state like Texas. Just there would be different flavors, right? It would just be, and that's pretty much what happened in the 1770s. So each state wrote its own constitution, and there also weren't really models, so they're all making it up. So Pennsylvania didn't have a governor, and they had elections every year, and their judges were also elected, and if you wanted to pass a law in Pennsylvania, you had to publish it in the newspaper for a year so that everybody in the whole state could see it before the legislature was allowed to vote on it. The most democratic, like direct democracy. And so each state was like a different experiment. But there were also, the Union at the time in the 1770s was a little bit like the European Union. It was like 13 states that are just in a federation, like a loose federation of states. They had, they had 13 different currencies. There were 13 different navies. And so the only thing that held them together legally were the Articles of Confederation, which was basically a treaty for the sake of the war. Like, okay, we're trying to, we want to win our independence from Britain, so we're going to form a military alliance, essentially. And that wasn't really sustainable as an ongoing concern after the war, because Congress, under the Articles, they couldn't tax anybody, they couldn't deal with the debts of the states, they couldn't consolidate debt, they had all these different conflicts between the states, but Congress couldn't resolve them. So, and the Articles of Confederation couldn't be amended. So they realized, all right, well, we're going to have a constitution for the whole federal government. And what they really were looking at were what are the things that have worked in the states and what are the things that didn't work in the states.
And also they were forced into certain political compromises between small states, large states, slaveholding states, non-slaveholding states, sort of, I think you present kind of jerry-rigged arrangements that have never been fully resolved, maybe down to the present day. Let me ask you, because part of the book is a kind of a history of thoughts about the Constitution, which changed very quickly even. But you had this sort of initial Enlightenment view that you talk about of the Constitution as, and even the sort of federal system as being like having the mechanistic perfection of a clock, a very kind of chain of being 18th century idea that at least some of the founders seem to bring to the table. Something that I think you would not endorse as having the perpetuated up to the present day. But what was the sort of consequence of that way of thinking about the Constitution when they all get together and try to take these different models and make a single document?
Yeah, I mean, I think they're still struggling with the whole novelty of the idea, right? Like they
still today.
Well, even when they're doing it, they're like, well, what is it going to mean if we write it down? Like they're just like England doesn't have a written constitution, and this was still a new thing, even though it'd been experimented with in the States, and so they want to get it right, but they also don't have any reason to believe they're going to get it right? Like it's 55 guys. I think 70 are elected, only 55 show up, only 39 of them sign it, like a lot of them leave. the South keeps threatening to walk out over slavery because the North, there's slavery is illegal in the northern states and the southern states are really committed to it. Like there's
Madison on any given day maybe puts down the notes that we consider so canonical.
Yeah.
10% of what happened.
Sometimes he writes stuff down, then he goes back and
It seems so much
like
more unruly
yeah.
and kind of improvisational than the sort of picture we've received down from the ages of this sort of miracle in Philadelphia.
Yeah, no, they really do think of it as, this is just like a really hard meeting. like this is your nightmare of a meeting. Like there's just some people that are not going to be helpful in this meeting. And you're on the Zoom call and you're like, oh geez, but they're committed to it, like the country's going to fall apart if they can't do this. Like they know the union will collapse. So they have to come up with something. And then they also know, because they learned this from the States, they have to have a mechanism in it to fix it when it breaks, because they know it's going to break. They don't think it's going to, the average, the expectation is it might last a generation. That would be amazing. But they figure it's going to need fixing. They don't know anything about the population. They all expect slavery to blow up and become, that it's like they have not solved slavery in Philadelphia. So they know that's going to be a problem. They're just kicking it down the road. So they put in this mechanism for amending the Constitution, which they figure people will use all the time.
Is that right? Because that's what I wanted to talk about, because I think maybe the novel contribution of your book is the way in which the founders both assumed there would be a robust amendment process and how that expectation has been kind of foiled. So let's talk about Article 5 for all its, prolixity and confusion, and why it in fact has not proven to be the kind of panacea we might have thought. Let's start with, well, first of all, I was really struck, one of the many revelations in the book, again, going as against the sort of received wisdom of the miracle in Philadelphia. Madison, Washington, Hamilton, they weren't so happy with the final product. It was like, oh, this meeting, let's just put it to a close. But one of their views was, at least we have an amendment process. So I think it's fair to say that a central theme of your book is how it hasn't worked out that way. Let me just start with, where were they in terms of how the amendment process would work and why it was important and how it would solve some of the problems that they were perceiving at the time?
Well, they knew that, for instance, people of Massachusetts had rejected the first constitution that was provided for them to ratify because it didn't have an amendment provision, or not one that the people could use. And Massachusetts had to go back and write a whole new constitution. So they knew they had to have an amendment provision. And they knew there's just no way the Constitution would be ratified without it.
Even that, it's not that it wouldn't work, it wouldn't even be ratified.
They knew it wouldn't be ratified without it. Yeah, and in fact, what happened when the Constitution goes to the states, there's 13 states, 9 of them have to approve it for it to become law. But they know all 13 have to approve it, or like what kind of a thing? Like what are the other 4 going to do? Just like leave? Like they know they have to have all of them. And so it's like very close votes, and like New Hampshire has a ratifying convention, they can't even decide, they just leave. Like people are like, what is this? What are we supposed to do with this? We would like to amend it right now. And so the states come up with 200 new amendments. They're like, all right, we'll ratify it if you do this, that, this, and the other thing. And the Federalists, who are the guys who want to convince people to ratify, they say, you know what? Let's just ratify now and we'll amend it immediately. We recognize we screwed up, but ratify it first and then we'll amend it. Because if we amend it first, we have to have another convention, and that sucked. Like there's a famous, very funny exchange between Jefferson and Madison. Jefferson spends a constitutional convention in Paris. He's not there in Philadelphia, where it is really, really hot, and damp, muggy, horrible, smelly hot. Yeah. And in Philadelphia, they have nailed the windows shut in the building because it's top secret. So it's a bad meeting. There's some horrible people at it. It's really hard to agree on anything. and they're hot, and they all miss their wives. And they're also been sequestered. They can't even write to their wives, you know. Some of these guys just leave because, like, their wife's going to give birth. Like, it's really hard. And Jefferson writes letters like, you did a pretty good job, but obviously the consent of the governed means that the unborn haven't consent. So we'll have to do this again every 20 years. And Madison's like, dude, you were not there. We are not doing this again in 20 years. Like, we can just amend it. Like, we do not, like, they really don't want to have another convention. So they win the fight that says, like, just ratify it, and then we'll amend it later. And that's how we get to the Bill of Rights. So the first 10 amendments, which we call the Bill of Rights, they're immediately amended. I mean, immediately the Constitution is deficient. Immediately that has to be addressed. But what's so weird about it all is that they didn't understand that amending would become more difficult with time. And that's largely it's because there were no political parties at the time. So imagine how much Congress could get done, for instance, if there were no political parties. Like, there's no structural hurdle that is about cabals of people deciding to screw other cabals of people, and the country suffers. But by that happens by 1800. There's a two-party system by 1800. And then after that, the math problem that the amendment mechanism was meant to solve, like, it shouldn't be too easy to amend the Constitution, but also shouldn't be too hard. It immediately becomes too hard.
Yeah, I wanted to talk a little bit more about that because it happens so quickly, and so much of your book is about a series of surprises that eventuate pretty much from the get-go. So let's talk about political parties in particular. We see them as just sort of a built-in feature of the American political system. They didn't, right? They had in mind possibly a whole series of factions, and you can see the different stalemates we've had in recent years would be very different if there was sort of one party for whatever, the president, but there were many others assembled. But this two-party system and its rough parity between people have made any kind of sort of serious inroad nearly impossible. Why didn't they foresee political parties, and what made that a surprise development in really within few years of the passage of the Constitution?
Yeah, I think they were able to anticipate sectional tensions because they experienced that. They knew that most people were like, I'm a person from New York, or I'm a person from Virginia, but that most people didn't even think of themselves as Americans. They knew that the states were going to have interests. Like, if you think about all the checks and balances that are in the Constitution, it's the federalism problem, right? The federal government has power, and the states have to also have power and be sovereign. And then it's what do you do when the states group together? Maybe they're going to be enough states with shared interests that they could oppress the other states, right? That's the big fear of the small states. We're too small. The reason we have 2 senators from every state is the small states said, damn it, we'll not sign this Constitution unless we have some way that we're just as powerful as the big states. So, we have this is why we have the weirdness of the Electoral College and the weirdness of the Senate, right? And
which I can just point out is really an inroad to a compromise of popular sovereignty. In a perfect world, a majority would, in fact, control. But we have to this day a form of minority control based on this initial compromise that's never been.
Yeah. And I would say it was also the case, most of the states had similar, we call those the aristocratic provisions of the early constitutions, like where, all kinds of aristocratic things, like that the state assembly was really chosen by the governor, say, right? Like, we wouldn't stand for that. Like, people should elect, your legislators. But there were a lot of aristocratic provisions in a lot of the states, and they all amended them out. Because by the 1830s, the country is really becoming quite democratic. Like, by the 1830s, And I know to modern Americans this sounds not super democratic, but by the standards of anywhere in the world at the time, all white men, even people who owned nothing, men who owned absolutely no property at all could vote. That was not the case anywhere in the world. And that changed, like, then those people were like, we have to amend our Constitution.
Right.
And there were a lot of proposals to eliminate those aristocratic provisions of the federal Constitution at that same time, because everybody was like, oh, we're doing this, and this, and this. Let's also do that for the national government. And nothing could ever get done.
Yeah. And that is the story writ large, it seems to me, of the book. So now we move to, I think, what is the really signal contribution. We've had a lot of general criticism of where the Constitution started, but there's always this notion of structurally it has in place the kinds of separation of powers and the like to solve problems. But this is a huge part of the structure as they first conceptualized it, some amendment process. And I think that your book, Jill, I mean, we have 12,000 or something like that efforts to really amend the Constitution just being introduced in Congress. And you could say 27 actual amendments. Even that might overstate things because you had the first flurry that were always contemplated of the Bill of Rights. And then obviously the Civil War amendments, which we had to fight a civil war for. Well, let me just ask you, it might seem like what your story is largely about is just an overly stultified, impossible to execute amendment process. How did that happen? Do you think the framers blundered? Did they just want the hell out of hot Philadelphia? Why do we have what you've pointed out and you sort of chronicle is the sort of vantage point of just a essential and yet not fully. You've spoken about the amendment process, the self-cleaning button in other parts of your work. The button, I think, works sometimes, doesn't work other times. What went wrong?
Well, I think that in the larger sweep of American history, by 1803, so the 11th and 12th Amendment, those are just like little fixes, stuff that was like really screwed up. But then by 1803, a bunch of northern states start formally proposing, holding a constitutional convention and proposing amendments to end the Electoral College because it advantages the slave South. And they also are opposed to slavery, but they just want more political power. This isn't an abolitionist movement, right?
And can I just note that that Article 5 started by saying we're not going to mess with that
Can't mess with the slave trade.
1808, but now it happened.
Yeah.
Can you, maybe because when you read it, it's kind of dramatic. It feels like, hey, maybe this will happen. We'll be okay.
Yeah.
Tell us a little bit about.
So when they figured out what to put in the amendment clause, they say here's how you can amend the Constitution. It has to be past both houses of Congress by a 2/3 majority. That happens, it goes to the states, and it has to be ratified by 3/4 of the states. And then there are two things you can never do to fix this Constitution. Well, one thing you can only do within you can't do for 20 years. You cannot amend the Constitution to abolish the slave trade for 20 years. That was a concession to the slave states, who are like, if we put in an amendment provision, you guys are next thing you know, you're gonna wanna end the slave trade. So we're gonna walk, and the North again concedes. And it was like, okay, but we'll only give you 20 years. And everybody understands the slave trade is gonna end. That's different from slavery. It's just, there's gonna be no more forced migration of Black men and women and children from Africa. And then the other thing they say, then the small states say, hey, this is why it was a terrible meeting. The small states say, the slave states just got this big concession in Article 5. We want one. And we want this thing with the Senate to be unamendable. So Article 5 says, you can... Meaning
everybody gets 2 senators.
Everyone has 2 senators.
It's a total...
Nothing to do with the population.
Popular sovereignty.
And this can never be amended unless every state agrees to it. Like, you can't get that out of the Constitution by a constitutional amendment. And that was just like another political compromise. So immediately the North is like, okay, we have no power in the Senate because it's like this two-state thing. We don't have that population. We have no power in the Electoral College because of the 3/5 clause.
What is the 3/5
The
clause?
3/5 clause is the other giant math error of the Constitution, which is the compromise. It's really hard to accept how new it was, but the idea that people would be represented in a legislative body in proportion to their population was new. So the House of Representatives, where the number of representatives you have is proportionate to the number of people in your state. Like California, I don't know how many people do you have in the House? A lot.
A lot.
Yeah, from Vermont. We have one, I think.
50.
You maybe have 50, right? So okay, that seems,
And more coming.
that seems really fair, right? Like, I think we're just like, okay, well, if you have this many people, you should have a few more people representing your interests. That was new, but that created a huge problem because in the states that had slavery, human beings were not counted as persons in the census, they were counted as property. And yet the slave states wanted to be able to count them as people in order to have more representation in Congress, even though they were not, those representatives would not be representing the interests of the people who were held in human bondage. And the North was like, you can't, well, if you're going to do that, then we're going to count our cattle. Like, if we're going to count property, then we'll count our horses. Like, you can't just have all this political power because you're enslaving other human beings, which is wrong in the first place. And they came up with this idea, this compromise, which was really a Madison's suggestion, that the enslaved population was counted as 3/5 of a person for the purpose of representation.
Pretty grotesque.
This is also how the Electoral College works, because the Electoral College, your state's delegation is your 2 senators, everyone only has 2, plus your representatives. But this is why 4 of the 5 first presidents came from Virginia, because Virginia was the biggest population and the biggest slave population, and the Virginians won every election nationally because of the 3/5 clause. So by 1803, I'm sorry, it's a long answer.
No, it's all good.
By 1803,
It's also why the capital turns out to be in Washington, D.C., a
yes,
southern state.
it's like it's a disastrous compromise. I mean, the ethical piece of it, the moral piece of it, the human suffering. But the North is like, we never should have agreed to this crap. This is crazy. We're never going to have any political power. So they start really organizing around the idea of abolishing the Electoral College. And at just that point, in 1803, comes Marbury versus Madison. The Supreme Court says, you know what? You want to change the Constitution, come to us. Because, although it doesn't say this in the Constitution, we can change the Constitution because we interpret those words. We are the last, final, and exclusive arbiter of the meaning of the Constitution. Not the people, we are. And until the Civil War, that is the solution, right? Okay, I guess we're just not going to be able to do anything about the Constitution unless we go through the Supreme Court. And
which includes, by the Civil War, the Dred Scott decision.
Yeah, it's like 5 of the 9 are Southern slave owners at that point, including the author of the Dred Scott decision. He's a Marylander, but... So there's just this change where, like, the idea that you would be able to get an amendment through, you can't. Because pretty much the only thing people want to amend the Constitution about is slavery. And so by then the abolitionist movement has started, and then the big debate that abolitionists have, as you know, is like some of them are like, the Constitution is horrible. William Lloyd Garrison burns it and says that it's an agreement with death and a covenant with hell, and he sets it on fire. And then Frederick Douglass, the most important and most influential Black abolitionist, he agrees with that for a while, and then he's like, it doesn't ever say that slavery is okay. If anything, it suggests that it's bad. So let's just say the Constitution is on our side instead. And you know what? We can interpret the Constitution, not the Supreme Court. He doesn't, like Dred Scott, Lincoln and Frederick Douglass both say, like, the Supreme Court decision is just wrong.
Yeah.
This Constitution means that slavery is wrong. And, it takes a civil war and 750,000 people to die to get to that. But that whole process, those decades of political struggle, is really about the Constitution just cannot be made to end slavery.
Yeah. So, that says it exactly. And although the 14th Amendment in particular is a triumph of sorts in this overall arc, wow, did it take a lot of fighting. And the point you make, even back in the state constitutions in Massachusetts, there was an argument to be made that, no, the constitutional language already provides for the kind of equality that the southern states.
Yeah, so that's a good point. So in the North, this woman, Elizabeth Bett, went to the court in Massachusetts after the 1780 Constitution, and she said, it says right here, all men are created equal. I'm obviously not a slave. I'm free, and I'm equal, and I'm, live with it. And she wins. And these cases end slavery. Like, the people's capacity to amend the Constitution by declaring their own rights and insisting that their rights be recognized works in some states. And you can't do that federally.
Well, that's where I wanted to go, because it does seem like an almost elegy of the amendment process is the Equal Rights Amendment, which has this tortuous history and, in fact, is never enacted. And you take it, Jill, as more than just another failed amendment, but actually a kind of a demonstration, Article 5 is basically a dead letter. That self-cleaning button is just not working anymore. Can you explain what it is about that process that not only fails on its own terms, but actually, in your view, kind of puts an end to the whole Article 5 process? And I think is sort of responsible for the point you made 20 minutes ago about how we don't really think of we the people anymore as being, something that we own and a principle of popular sovereignty that, in fact, the Constitution embodies. Yeah,
so there were 4 constitutional amendments passed between 1961 and 1971. That's not that long ago. Yeah. And the last of them, in 1971, lowered the voting age from 21 to 18. Which was really a product of the student anti-war movement, right? Because you could be drafted at 18 to go fight in Vietnam, but you couldn't vote until you were 21. So the sort of amendment process was working. There's actually a lot of other amendments seem very likely to go ahead in that period, that 61 to 71. And the next one that pretty much everybody thinks is, will become the next amendment, the 27th Amendment, will be the Equal Rights Amendment. It's passed by Congress in 1972. Opinion polls put, it's like 80% of Americans support it. It's like this is still the end of the civil rights era. And, equal rights for women just it's just really not that controversial. And the people that have been working for its passage through Congress kind of just think ratification is going to be downhill on skis. It's just not going to be an issue. There's going to be, this is not going to be a problem.
And it's introduced 1980s, or when does it first?
It ends up expiring in the 80s. Yeah. And so the last kind of thing that happens before it passes Congress is there's a deadline attached to it, which becomes a problem. But very quickly, a huge social movement is organized to oppose the equal rights. It's called the Stop ERA movement, and it is led by the genius political organizer Phyllis Schlafly. And you don't have to defeat an amendment in that many states to defeat an amendment.
And that's the general principle in Article 5, right? It's one thing to introduce in Congress, but what turns out to be labyrinthine and more or less impossible in our given kind of polarized society is making its way through all the states, yeah?
Yeah. It's just, you have to have a ground game in the states.
Right.
And if there's opposition to you, and the opposition has a better ground game in the states, and this was just a case where the pro-ERA people just didn't anticipate, they were totally blindsided by that. So at that point, like that is a period in which, say, the women's rights movement was looking both to the courts and to amendment, right? They were both like, okay, seeking reproductive rights. And there's in 1965, the Supreme Court rules that contraception is legal. It's fine. You can. It's not. It doesn't violate the Constitution to provide contraception. So they're looking for Supreme Court cases, but they're also like, we should constitutionalize equal rights. This seems like we should do that. That's better. I guess maybe it's worth saying, like, getting the Supreme Court to recognize a right is a huge success, right? Like Roe versus Wade, if you were a supporter of abortion rights in 1973, the court says that is a fundamental constitutional right. But it's not as big as a success as a constitutional amendment, because the court can, as happened in the Dobbs decision in 2022, the court just overruled Roe and said, well, we used to think this was a constitutional right, but we were wrong then. Whereas a constitutional amendment is just as hard to undo as it is to do. Like a constitutional amendment becomes part of the Constitution in a different way than a judicial decision does. So, but at any rate, after the ERA fails, the left is like, we're not going to try that again. Because losing an amendment is a huge problem. Like if the same-sex marriage movement had gone for a constitutional amendment instead of to the Supreme Court, in 2015, the Supreme Court said same-sex marriage is not a violation of the Constitution, as a guaranteed constitutional right. It would have been better because that seems sort of vulnerable now. But if they'd gone for a constitutional amendment and lost, that loss is so terrible. So I really, since the ERA, there just really isn't, that's like, my lifetime, like there's just not, people don't try to amend the Constitution anymore at all. Like we accept that it can't be done. And by not doing it, we basically remove ourselves as authors of the Constitution.
Can you talk a little bit more about that? Yeah, and this goes back to we the people, right? I mean, the whole idea is a kind of popular sovereignty. And well, let me move on a little, because you note that's not exactly the end of the story. So as formal amendments become more or less outside the purview of the political process, there are these things called informal amendments that serve a similar purpose of kind of being a safety valve to kind of let out steam for really essential problems in the Constitution that are not otherwise taken care of. Can you talk a little bit about the informal amendment process that you discuss and how it serves, but also doesn't fully serve the ideal of popular sovereignty that is really we the people?
Yeah, I mean, there are a lot of ways that the Constitution changes all the time, like just things that Congress does kind of nudge the Constitution in certain directions. Social movements nudge the Constitution in certain directions, even before things get to the Supreme Court, right? The states are going to start, decriminalizing same-sex marriage or making civil unions legal. Like, there's just like a lot of movement in terms of what is constitutional in this country. And legal scholars call all of that the informal amendment process. But the most common thing is for the Supreme Court to change the meaning of the word. So the Second Amendment before 2008 was never understood by any Supreme Court to mean an individual right to bear arms. It was always associated with the militia. It didn't mean you couldn't own guns, but it just meant that owning guns was not a fundamental constitutional right as a federal matter. But the Supreme Court offers a different interpretation, and then that becomes that's the Constitution. There's a lot of instability there because so much now hinges on the Supreme Court appointments. So it's by the 1980s that the Supreme Court appointments become what they are now, which is like, who's he going to appoint? Then they're like the Oscar campaigns to like support or denounce a possible nominee, like what happened to Kavanaugh, or what happened to Robert Bork, or it's just so much intense stuff about. There's like tons of political harassment of the justices, even of their clerks, their death threats and possible assassination attempts. Like the Supreme Court just it's a deformity of the constitutional arrangement that the Supreme Court has all this power. And now like just very recently, we're in a really different place where the executive branch is like, no, we decide what the Constitution means. You know, birthright citizenship does not exist. Or like if Trump says it, then it is constitutional. And if he does it, it's constitutional. And if he doesn't, it's like, that is really new, but that is a very different kind of deformity than the court's role.
And I want to talk a little bit more about that. So we have, in the broad scheme of things, it looks like Article 5 you feel is a dead letter, and it leaves there are certain Ackerman in the law talks about constitutional moments, and you focus on certain kinds of times, or the New Deal, Reconstruction, maybe even Jacksonian democracy, where the Constitution changes effectively. Do you see us now as in one of those periods? And what is the sort of constitutional status of these really outsized assertions of executive branch authority by Trump, and how does it accord with the general, we the people, lonely back here about popular sovereignty and whether or not it's basically we've left behind notions of the people really deciding.
Yeah. I mean, I think it is a fair claim to say that its amendability is foundational to any written constitution and its legitimacy. And when a constitution is no longer amendable, it is no longer legitimate. And that's the risk. And there have been periods in American history where that has been the case, like the legitimacy of the Constitution did not exist before the Civil War. I mean, the South wrote its own Constitution, right?
And
like
that's why
John Brown wrote his own Constitution, right? Like I'm not so sure that our Constitution has legitimacy with the broad swath of the American people right now, and for different reasons. One thing that I would say is shared in common by, let's say, the people who were active in the Tea Party movement in 2009, 2010, they were really interested in the Constitution and taking back the people's power over the Constitution. That was why they dressed up in the tri-cornered hats, and they felt that the Affordable Care Act of 2009, the Obama's Health Care Act, was unconstitutional. They were furious that the Supreme Court didn't strike it down, and they felt like it's our Constitution, and we think that's wrong. And they didn't win. They had an enormous influence on politics. Their political frustration was a lot of what gets, what leads to the reconfiguration of the Republican Party. But those people have a lot in common with, I don't know if you guys had a lot of the No Kings rallies out this way. Yeah. When I went to watch some No Kings rallies, and it really felt like being at a Tea Party rally. There were the tri-cornered hats and the knee breeches, and people are carrying around their paper constitutions. And I think if we could sort of realize, wow, no matter who feels left out, it's bad that people like ordinary citizens feel they have no say whatsoever in basic matters of constitutional rights anymore. And it really needs saying, Americans also don't trust one another to make decisions about constitutional rights. So there have been a lot of efforts to say, look, we really need a new constitutional convention. And that's been really a move made by the right since the late 1950s, when they want to have a constitutional convention to overturn Brown v. Board of Education, which is the decision that ruled that segregation is unconstitutional. And the left has always said, God damn it, there's no way we're having a constitutional convention. We don't trust our fellow Americans not to just dismantle all of the civil rights movement. And that's been the case ever since.
Yeah.
Like, it would be so bad if we had a convention because people we disagree with would win. And I get that. But on the other hand, that's democracy. If the people who disagree with win, that's because you lost. You didn't make a strong enough argument. You didn't convince people. Either we have that or we don't have that. But the other thing is that would be bad. That could go badly. But also at this point, compared to what? That's a piece I don't really quite get. Right. I don't think we're ready to have a constitutional convention because I don't think anybody knows how to sit in a hot room and argue with people that they disagree with anymore. I think high schoolers know how to do that because that's what you do in school all day. But grown-ups do not know how to do that anymore. So we can't have a constitutional convention until people are willing to learn how to be good democratic citizens again. But I just think it's important to recognize we don't really have a constitution that people feel sovereign over.
Look, which is sort of the bottom line and a somewhat sobering one. And you yourself, Jill, like pointed out, look, the amendment process, there's sort of a three-part possibility. The amendment process is no longer happening. I think we do accept, maybe still, but it's eroding, the court stepping in and giving us kind of from on high meaning about the Constitution, but that's not the way, certainly a real erosion of popular sovereignty. And then there's the third possibility, which you say, which is this kind of popular revolt. So one thing you can say about this current period of polarization we're in is it does, at least, as you say, engage, people in sort of first principles of what's the Constitution mean. Even January 6th itself, were people who were sort of misbegotten patriots. So you probably face this question a lot. I do as well. But one way of reading the book is, we really needed an amendment process. It really isn't there, and we are still fighting the wars of the 18th century and not mending and amending, and we still have these built-in difficulties. But another is to try to, see a way clear towards some kind of consensus, maybe even a new constitutional convention. Do you see any respect in which the very sort of basic roiled debates we are now having about the meaning of the Constitution kind of gives way to some sort of resolution that we really haven't had in 200 years?
Well, I think what we see a lot of and are likely to see quite a bit more of as much of the federal government is, in fact, dismantled are a lot more states' rights claims and state-to-state pacts. I think we will have a map of the United States that is kind of pro-vaccine and anti-vaccine that looks quite a bit like the Civil War map. The first time maps of the United States were colored in red and blue was for free and slave states during the Civil War. And this is very uncanny.
And fair to say, we're sort of still there.
It's very uncanny to look at those maps because even during COVID, the sort of like mask mandate, non-mask mandate, we just are still living in the geography of the Civil War. So I think we could see, a lot more disunion and a lot more agitation in the states for state constitutional rights, carving out, in the same way after Dobbs, there were a lot of constitutional amendments to preserve reproductive rights, say, and we could go back to a kind of Articles of Confederation version of the Constitution, except that what the current occupant of the White House wants is absolute control over everything, but without a federal government, just him and an army. So I think what, in fact, we really have, the reason you need to have an amendment clause in the first place is without a peaceable, ameliorist way to improve things, including in moral ways, by making amends, by mending your ways. Amendment has a real moral meaning. Without this kind of peaceful, gradualist mechanism, the only way to fundamentally change the government is through insurrection. So you could think about Article 5 as the anti-insurrection mechanism, and we really live in a very insurrectionary age. I mean, just the style of politics is insurrectionary. I mean, if you were to think about, say, if the Supreme Court they wouldn't do this, but if they were to go back and flip back to the previous interpretation of the Second Amendment and say this is just the states can do whatever they want with regard to guns. There's no federal whatever here. It's just about the militia. I don't think we would expect that to be received without violence. There just feels like things just feel powder keggy in a way that the entire ambition of a constitution is to avert. So I do think there's a way forward, and I do actually think that this 250th anniversary, which people are like, oh geez, like what is that going to be? Or, some people are very excited about it, but I don't think anybody's really thinking about it as a possible moment for renewing the very idea of who we are as a people and what it means to agree and to disagree and then come to some kind of an agreement over how we want to govern ourselves.
Yeah, I mean, that really seems like the sort of basic lesson here. And it feels to me in a way that it hasn't. When you talked about some of the problems with the founding, I was put in mind of 50 years ago, or not quite, but 35 or whatever, I was clerking for Justice Marshall at the 200th anniversary of the Constitution itself. And he made the point that we, the people, the very phrase you said was itself so flawed. And I feel as if we have in the offing still a failure to have come to grips with some of those difficulties, and it's just not clear. Powder keg is really the way to put it in a way that just hasn't been the case in our modern political life. I wanted to make sure to spend some time, because many of our folks here are from either high school students or teachers of the Constitution in SDSU and UCSD. Do you have any thoughts about how the Constitution is taught today, how it should be taught? I mean, what some of this brought home to me is we have a kind of, and I think it's going to come again. You talked about it 50 years ago with the Disney figures, and we need to amend, and a whole kind of American jingoistic way of thinking about a certain perfection in Philadelphia that doesn't really seem to accord with what happened there. What do you think about how the Constitution is taught in high school, in college, even in law school? Whether that should change, and what the occasion of this major moment of reflection provides for making those sorts of changes.
Yeah. I mean, one of the things I would say about college is constitutional history is not taught in history departments anymore. Like, it really just is not taught. You don't take constitutional history really in college. Right. Often the whole study of the Constitution has just moved to the law schools. And law schools just have a very instrumentalist, we got to figure out what we can get out of it. What is their objective here? What are the rules? What are the doctrines? We can apply them. But the kind of scrutiny, the kind of creativity and imagination that you might bring to the study of the Constitution.
First principles is a word. Yeah.
What law schools are doing. And what I try to do in this book is say, I don't the opinions of the Supreme Court really are important, but actually, the whole body of the people arguing about the Constitution for all of American history, sending petitions to Congress, going to marches, that also is constitutional history. The Supreme Court doesn't think of that as constitutional text that we can refer to. I don't really honestly see why not. Those are documents too. The Federalist Papers are just the opinions of three guys. No, they were very important, and they're beautifully written and really incredibly influential political theory. But there's a lot of petitions written by, for instance, enslaved people in the 1790s, 1780s. Women that are an incredible body of evidence. There are the constitutional proceedings of native nations, constitutional conventions. The book really tries to sort of say, we'd have a better understanding of the Constitution now if we had a better understanding of its past. But I think the way I teach the Constitution, when I teach it, which I actually think I've seen high school students do this way better than my college students who do it very well, is just prepare for a constitutional convention and have one. As a kind of class, decide what are if you could imagine three things you would like the Constitution to be different. Maybe you want maybe you do want to abolish birthright citizenship. Maybe another idea would be an environmental protection amendment. Maybe another idea would be term limits for the Supreme Court, and just randomly divide the students for and against. And then they have to prepare arguments for and against and do research. And then you have like pizza, and you don't nail the windows shut, and you argue it out.
Air conditioning.
Yeah, I always have I have a group of my students be the rules committee, and they have to come up with the rules.
Yeah.
Because it's not clear to me, like, how many people in the room have to agree on it for it to pass. We usually...
You've done this with your own family, right?
I do this. We do this as a family, too. But, like, in a class, like, I divide the students into delegations, and, there's the pro-birthright citizen delegation and the anti, and there's the pro-environmental amendment and the anti, and you don't get to pick, because it's not about what you believe. It's about practicing how to argue. It's like a law school thing. Right. And then, then we have the group of kids who decide to make the rules and elect officers, and we spend days and days arguing it out and seeing what wins. And I think just doing that, first of all, it's like you'll use those skills the rest of your life. Any meeting you have to sit through with people that you don't really like, whose opinions you don't totally respect. Anytime you have to try to persuade somebody, anytime you go on jury duty, like when you're at a family dinner, like it's also very, very fun to really let kids go crazy arguing with one another, and have the kids be the rule makers so they can say, you're out of line, that was an ad hominem attack, could you bring evidence to the floor, sir? It's really fun. And
it's sort of a revelation for them that maybe they have an investment, a role in actually deciding what is our fundamental charter, You've said generally, Jill, that you want to one of the goals here is to put people before cases. And can you speak a little bit more to that and how you think it's not the case in current constitutional discussions, and what we're missing and how possibly to bring back that sort of popular sovereignty, central feature?
Yeah, I mean, honestly, like maybe it's a secret agenda of the book, but I guess I wish that, so in the 19th century, Black men held constitutional conventions. There were more than 200 of them starting in 1829, because they couldn't vote, they couldn't participate in the constitutional conventions in the states, but they basically just had conventions all over the country. In the free states, they elected officers, they had deliberations, they published the proceedings, and they were just arguing about the Constitution. And has the Supreme Court ever cited any of those things? Like, as if those are, like, it's as if that stuff just didn't happen. So part of the object of the book is like, there's a lot of people, there's a lot of contestation over the meaning of the Constitution, and it's been rendered invisible to us by the narrowness of the historical record that appears to be of concern of the current court. And that just blowing that up and being like, wow, and it wouldn't, like, or like all the people that organized for the prohibition, to ban alcohol, was a really huge social movement, and so was the movement to repeal it. And like, there's just a lot of constitutional agitation there that involves like some fundamental ideas about who gets to decide what's good and what's wrong and what's true and what's false. I don't know, I just really want people to feel like there is a history that we are part of. When, the slogan for the bicentennial, not of the Constitution, but in 1976 was 200 years, not 200 years ago. And that was, the sensibilities, like, when we think about the 250th, I don't want to sit around and talk about 1776.
Right.
I know, I want to talk about, like, what happened in the 250 years. Not 250 years ago. 250 years of constitutional struggle. Doesn't really feel like where we need to be.
Talking Feds is supported by the Brennan Center for Justice. In this new political era, the Brennan Center will do what they do best: defend the Constitution and the rule of law. They're prepared to fight against presidential overreach and will continue advocating for reforms to resist weaponized government, stop billionaires from corrupting our elections, and ensure every eligible American has the freedom to vote. Stay informed by visiting BrennanCenter.org.
Is the book designed to be actually taught in schools? What do you hope to be the sort of contribution of it to overall pedagogy of the Constitution?
Yeah, I wrote this, it's a sequel to a book I wrote in 2018 called These Truths, which is the history of the United States. And there is a textbook edition of These Truths. There's the one that looks like this, but then there's a textbook one. And it has like lesson plans and whatever. And I revised that. There's a new edition of that coming out. And I actually just put a lot more of these stories of ordinary people trying to fight for their vision of the Constitution in the revised edition of the textbook of These Truths, because I feel like that's a more, like you can buy it, schools can adopt it, it comes with documents. Like, for pedagogical purposes, I think that it's the second edition of that textbook. I think there are some constitutional convention ideas in there. I think that makes sense. But there's actually a ton of this stuff going on. Like the University of Arizona, I think, has an annual constitutional convention. They bring high school kids from all over the country. They have a college one. I think people really feel like, we haven't, no state in this country has had a full constitutional convention since 1986.
Right.
Even when I was growing up, I remember states having constitutional conventions because it was like, what are they doing over there in Michigan? And we just don't do that. And I think anything that gets people, kids, grown-ups, probably more grown-ups, because kids are better at this, in rooms together, arguing about stuff with respect and good faith can only help.
Yeah, and that's kind of a lost trail of history that comes through here, and not necessarily what you might call progressive, or there were a whole series of constitutional conventions in the wake of the Civil War amendments to pass so-called Redeemer constitutions. Is that what you come to try to sort of undo? Okay. I think I'd be remiss if we didn't talk just very briefly about the court and originalism. You've made clear that this is not a polemic against originalism, but it's being taken that way. And it's an obvious kind of comparison because it has to do with the marshaling of historical evidence, what the court does versus what a historian would do. What are your thoughts about, to the extent that our informal amendment process now consigns us to basically going along with what the court says? The sort of governing method of constitutional interpretation is this so-called dead, as Justice Scalia put it, or originalist idea. You find that problematic, yes? And what do you... Partly the book, the book has some aims that are absolutely opposed to originalism. Yeah. One is it wants to historicize originalism. Originalists insist that the only way to read the Constitution is the way they want to read the Constitution, and that this is the intended way, that this was how the Constitution was meant to be read in 1787. And sort of a substitution for the amendment process you've mentioned. And when conservatives failed to amend the Constitution, they invented originalism instead. And can you say that again? Conservatives really wanted to amend the Constitution all through, from 1954 on, right? Reverse Brown, overturn Roe, but they wanted to do that by amendment because the court was liberal. The Supreme Court was very liberal beginning in 1953 through, into the early 70s. And then became murkier. It doesn't become conservative until really into the 80s, but they didn't have the option of going to the court. And so they really elevated amendment as the proper constitutional mechanism. And then they found that they didn't have the votes. So they wanted to overturn Roe with a right to life amendment. They didn't get anywhere. They wanted to overturn Brown with a states' rights amendment. They didn't get anywhere. They wanted to have a constitutional convention. They wanted to have a balanced budget amendment. They didn't succeed. So by the time Reagan gets elected in 1980, then they're like, oh, you know what we'll do instead? We'll just go with the court. And then they just renounce, they say they only believe in amendment. And they don't believe in the court being active. They believe in the court being original. So because they don't want to say we're being activists, because they've just spent decades denouncing judicial activism. So they say, we're not going to be judicial activists. We're going to be
anti-activists were going to be originalists. And it's a rhetorical move. It's a brilliant one, and it's extremely successful. What it isn't is borne out by the historical record. So originalism is not original. The ideas about deferring to the original intent of the framers pop up here and there, and Dred Scott, for instance. We see them here and there. They pop up in the case that the segregationist schools make in Brown. But it is not some continuous piece of American constitutional history. It is a modern creation for a specific political purpose. And so I both want to historicize originalism, but also to say, because historians have been trying to say for a long time, whatever you think of originalism, you might disagree with it or agree with it, might think it's a great judicial philosophy or a terrible one. It's not history. It's just not. There's very little to do with how historians think about the past and the relationship between the past and the present and how to investigate it. So part of the reason to write the book was okay, you can disagree with my interpretation of history, but this is actually a history book. This is what a history book does. It asks a series of questions. It looks at a broad historical record. It comes up with a theory of change. It offers evidence in support of it. It's litigable. Someone else can come write a different book in next year, and people will be like, well, it turns out Lepore was wrong. But it is a work of historical research and scholarship.
Yeah, I mean, you say history is the art of making argument based on evidence, and it is really interesting. We could have a whole discussion about originalism, but it's this closed corpus, and one of the revelations in your book is that the various canonical sources, including even the Federalist Papers, which turned out to be important, and I didn't know this except through your book, just for the kind of debate within New York only, but we've given it much broader sort of purchase since then. Man, we could talk about this for forever. I do want to just underscore this basic point in a year that's going to be full of hagiographies about the Constitution, that to the extent we endorse this basic notion that the amendment process is essential and flawed in the case of our Constitution, it's got sobering implications for where we are right now. I wanted to ask you as a sort of closing question about this, just because it brings back the focus we've always had on the Constitution. So in the Harvard commencement, and one of the many revelations in the book, from 1774, there was a debate. Does the happiness of a people depend more on the Constitution itself or on the administration of it? I wonder if you have an answer to that for 2025.
Frederick Douglass gave this great speech. I think it's called The Constitution and American Life. And he says, it's not the Constitution that is the problem, nor even the government. It is the moral blindness of the American people, which I find very haunting. And I think that he was right. And that is to say, the Constitution requires articulation. This is a notion that people talked about in the 18th century as the spirit of the law.
Right.
It's just a piece of paper. It's only Madison said the Constitution is mere parchment without the endorsement of the American people, and that requires a fight, and not just deference to whoever happens to be declaring what the Constitution is and is not. So I agree with Douglass, but with Douglass, I also have faith that the blind can see.
Please join me in thanking Jill Lepore for her great new book, We the People. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.